Hello. Validity of a contract depends on that notion of free and informed consent. And usually there is no doubt about that because one person, a physical person or a legal person, is there, another one is there. Their mental capacity is not in question. They freely formed a contract, so the contract is valid. But sometimes it's not that clear because sometimes maybe one of your friends, maybe one of your relatives, like people you care about, uh, found themselves to be in a contract. And you think that the contract was signed in a sort of like abusive manner because the person, as you think, didn't have the exact mental capacity to understand what he or she was signing. Maybe some kind of a very disadvantageous contract with one of those loan sharks, or just a sale of huge immovable property under bad conditions, and so on and so on. So you think that the person you care about did not exactly understand what was going on. And if that person at the time was already under a protection regime, there was a protection mandate homologated, then there is no question the contract is not valid. But what happens if the weakness, the mental weakness, the loss of mental control, that weakness of spirit, faiblesse d'esprit, was not actually confirmed by the court at the time or before the time when the contract was signed. So, will the contract be valid or not? To start with, as we just discussed, if the contract was signed in a free and informed manner, it's valid, meaning that if it was signed under some kind of duress or in fear of something, or through some kind of fraud or fraudulent maneuvers or some kind of false information or misrepresentation, okay, well, you have arguments to go with and to invalidate the contract. But what if all the information was actually presented, but the person who was there to sign, as you think at least, could not actually appreciate like what was the information, what were the circumstances, what were the consequences, where will it go after? And probably you saw people like crying after, saying that I didn't know, I did not understand. And sometimes it works, sometimes it doesn't. So why is it? Let's go a little bit into the past and see how the old civil code, the civil code of Lower Canada, was treating the validity or incapacity to enter into a contract. As you can see, then it was not said that the person should necessarily be rendered or just by a court judgment legally inapt to invalidate his or her contracts. And well, the reality tells us that probably that's just and fair and good idea to think that not everyone who is legally not rendered inapt is actually ready to go thoroughly through some kind of a complicated contract like a bank contract or sales contract or so on and so on. Of course, when it comes to immovable property in Quebec, at least, you go through a notary and you have some hope that the notary would recognize that the person is not totally there. But if there was no clear sign, it's not the notary's job to go through some like medical evaluation. So even a notarial contract of that kind might be eventually invalidated, not because of the bad job of the notary. The notary did his or her job, but observing the mental condition of a person is like beyond the notary's job already. Uh, so later, in 1994, when the new civil code came in force, what was left of that article became Article 1398 now, which also says that the person should be capable of binding him or herself. The famous jurisprudence, particularly the famous decision in Thibodeau in 1961, which was applying the article of the previous code, the Article 986, it's still considered applicable now to the Article 1398. And there, the judges, particularly Mr. Justice Tachereau, said that the person should not be necessarily totally insane to think that his or her contract could be reasonably invalidated. Let's put it this way. And if we accept the rule as it is, the next question comes: how do we evaluate? Like, if the person is incapable enough to invalidate the contract, while the person was not yet rendered legally inept. So, no particular signs of grave, total, and incurable dementia, Alzheimer, God forbid, severe psychosis or something like that. But still, we think that the person had no particular, or at least required, control over his or her mind, or in French, that weakness of spirit, faiblesse d'esprit. Recently, or more or less recently, there was a case, here it is, of Cochon contre Savard, where the court was again applying the rule in Tachereau, and was discussing, in the particular situation, but still applying the existing rules by the time, and the court was discussing if this or that sign or particular fact would add to incapacity and or the incapability of binding him or herself. And in that case, the court decided that no, this was not valid. By the way, a contract of a donation, a gift, is also a contract, and in a certain situation, even the last will is also, at least the contract rules are applicable. So there might be a question with somebody of your elderly, if a particular donation or a particular addition to a will, at least, can be seen as valid or invalid. So these rules are much more applicable than we can think in the first place. And as you can see, the most important part is all about facts. So in that particular case, the court was looking into very much complicated mental history of a person. But again, nobody said that somebody should have all those indications to invalidate the contract. Those are just examples, so you can just see where the court was going and where the court was taking its idea to invalidate a particular juridical act, particular contract. So if ever you're in a situation when you have to contest a contract, of course, first of all, you have to consult a lawyer, because probably that will be easy, and if your ideas are wrong, it will save you a lot of money in order not to go into some desperate litigation. But if you have particularly good arguments. A lawyer would help you to structure them. But all in all, like, what kind of an argument should you have? Factual. You'll have to show that the person really was losing at this particular moment when the contract was signed, losing his or her control of mind. That the person could not really appreciate what's going on, could not really appreciate the aftermath on the level of like regular reasonable person, let's put it this way, exercising his or her like regular civil rights. So if you see that the memory, the speech, the behavior of the person is significantly more and permanently or constantly disorganized than just a sign of some kind of bad character or whatever. If a person is irritable, if a person is aggressive, if he's jumping from one topic to another, if his or her conclusions are way beyond reasonable, not like simply beyond reasonable as those of our neighbors who probably try to convince us that their soccer team is better than ours or vice versa, just beyond like regular emotional discussion. But when you just have this feeling that the person really doesn't have a clue what he or she is talking about, and if it lasts and it's not a situation of some kind of intoxication, it's just like the person pretends to be sane, but the more you listen, the more you look, the more you like cautiously doubt that. Then maybe you could compile a good bunch of particular facts with particular evidence, like affidavits, like testimonies, maybe something in writing, maybe some pictures, some videos, whatever, to show that the person probably could not appreciate what he or she was signing. And if that's the case, chances are, there is never a guarantee, of course, but chances are that you could proceed before court successfully asking to invalidate such a contract. Again, when it comes to legal matters, there is never such a thing as a guarantee, because it all depends on the judge. Even if you think that what you read in the civil code or any other law, like black letter of the law, totally, completely applies to your situation, so you think that your chances are 100%, most probably you're not exactly right, because fortunately or unfortunately, there are always nuances, fine aspects, and well, you cannot predict how the judge would appreciate the situation. But at least you could prepare the best way you can. Thank you, and have a nice day.